Now we are moving towards the definitions, how aggression, because after recognizing in 1974 by the United Nations, by the Security General Assembly of the Security Council, the definition in 1974, the United Nations General Assembly adopted a resolution in 1974 after the years of the negotiation. The purpose of definition of the aggression annexed to resolution was to give guidance to the Security Council in its determination of the existence of an act of aggression. The definition deals with the state act of the aggression and not the act of the individuals who may be responsible for the state act. The definition of the aggression mirrored the concept of the illegal use of force contained in Article 2, Clause Paragraph 4 of the Charter, and enumerated specific examples of the acts of the aggression, such as the invasions or attack by the armed forces of the state of the territory of another state. The core provision of 1974 definition, Article 1 and 3, were incorporated into part of the 2010 definition of the crime of aggression under the Rome Statute. The role of ILC Law Commission in defining the aggression. December 1981, the General Assembly revived the ILC's earlier mandate by requesting that the ILC resume work on the draft code of the offences against the peace and security of the mankind. In 1996, the ILC adopted a draft code of crime against the peace and the security of mankind, which contained Article 16 on the crime of the aggression. So, in this mandate, in this committee, the code wherein Article 6 regarding the crime of aggression, which states that an individual who is a leader or organizer actively participates in or orders the planning, preparation, initiation, or waging of aggression committed by a state shall be responsible for a crime of the aggression. Very interestingly, ILC's commentary on the Article 16 identifies the Nuremberg Charter and judgment as the primary source of the authority for the individual's criminal responsibility, but it neglects the 1974 United Nations General Assembly definition, which we have discussed earlier. The commentary also explained that the International ILC Law Commission did not address the question of the definition of the aggression by a state because this definition was beyond the scope of the code. Governments have not implemented the ILC's code as their attention, then turned to negotiating the statute of the ICC. The 1998 Rome Conference, the question whether or not to include the crime of aggression, and if so, how to define it, was one of the main disputes in July 98 diplomatic conference that led to adoption of the Rome Statute of International Criminal Court. Delegates could not agree on definition of the crime against of aggression, as some wanted only wars of aggression to be converted, whereas others wanted to use what is arguably the broader notion of acts of aggression contained in 1974 General Assembly definition. Even more difficult was question of whether the IEC should only prosecute crime of the aggression once the Security Council has determined the exercise of an act of the aggression by one state against another. As part of the final compromise, the crime of aggression was included in the list of crimes under jurisdiction of the court, but the definition and condition for the exercise of the jurisdiction were deferred for the consideration of the first review of the conference. Furthermore, what was the role? The crime of aggression, which had been described as the supreme international crime, was completely excluded from the subject matter of the jurisdiction of the ISTY and ISTR and the various hybrid tribunals. Therefore, none of these institutions have ever indicted or prosecuted a definition for crimes against peace or crime of the aggression. The ICC statute was the first statute since the drafting of the statutes for the Nuremberg or Tokyo tribunals to include the crime of aggression within the jurisdiction of the court. The Article 5, Paragraph 1, Clause D of the ICC states that the crime within the jurisdiction of the court. The crime which are under jurisdiction of the ICC, the jurisdiction of the court shall be limited to the most serious crimes of the concerns to the international community as a whole. The court has jurisdiction in accordance with this statute with respect to the crimes which are the crime of genocide, crime against humanity, war crimes, and crime of the aggression, which is included in the Article 5 of the ICC statute. But however, unlike the other crimes over which the ICC has jurisdiction, the crime of aggression was not defined in the ICC statute. Article 5, paragraph 2 of the ICC, which also called Rome Statute 1998 or 2002, sorry, explained that the definition will be decided upon in the future. Which article states that, I'm going to read out the language: the court shall exercise jurisdiction over the crime of aggression once a provision is adopted in accordance with the Article 121, 123, defining the war and setting out the conditions under which the court shall exercise jurisdiction with respect to the crime. Such provision shall be consistent with the relevant provision of the Charter of the United Nations. Resultantly, in a consequence, the ICC is not able to indict or prosecute a defendant for the crime of aggression until the state parties to the statute have agreed upon a definition of the aggression and have amended the statute accordingly. Article 121 and Article 123 of the ICC statute entails the amendment and review procedure for the ICC statute. But it is very difficult and $1 million question whether agreeing upon a definition of the aggression and the conditions under which the ICC would exercise its jurisdiction has proven difficult. Initially, the Rome Conference delegated the duty of the formulating a definition for aggression to a proprietary commission. Then in September 2002, the Assembly of the States Parties to Court, which is the management oversight and the legislative body of the ICC, and consists of the one representative from each state party, established a special working group on the crime of the aggression. The crime of aggression, and there's a Latin expression, unlike war crimes, crime against humanity and genocide, which fall under the us in bello, the crime of aggression developed from the principle governing recourse to conflict among the states, known as is ad bellum. Jus ad bellum is a law relating to the use of force and defines the legitimate reasons under which a state may engage in a war. Us in bello, on the other hand, which is based on the concept of the proportionality and other humanitarian principle designed to reduce unnecessary suffering, is a law which regulates the effects of the war by regulating practices through which wars have been fought. And the modern legal theory of this principle is ad bellum, developed after the First World War. After the destruction and devastation of this war, the international community came together to analyze the criminality of war. Although the Assembly of the League of Nations worked towards prohibiting the unlawful use of force as a tool of foreign policy, which actually did a little to advance the restrictions on use of the force. However, the signing of the Kellogg-Briand Pact in 1928 was considered a much more significant event. With respect to the prohibiting the unlawful use of force, the main provision of the Kellogg-Briand Pact are the Article 1 and Article 2, which is regarding the crime against aggression, crime against peace, use of force. And thereafter, that pact were later embodied in the Article 2, Paragraph 4 of the UN Charter, which prohibits the threat or use of force. which states that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purpose of the United Nations. And thereafter, this article, however, Article 2, paragraph 4 does not provide a complete prohibition on the use of force by the state. There are certain instances under which a use of force is deemed admissible. As per the Article 51, Article 2, paragraph 4 prohibit the use of force, but the exception and condition provided in Article 51 of the United Nations Charter, which states that nothing in the present charter shall impair the inherent rights of the individuals or collective self-defense if an armed attack occurs against the member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by the members in the exercise of this right of self-defense shall be immediately reported to the Security Council and shall not in any way affect the authority and responsibility the Security Council under the present charter to take at any time such action as it deems necessary in order to maintain or restore international peace and security. So Article 51 of the United Nations Charter clearly indicates that use of force is permitted. And in addition to self-defense, exceptions use of force is also permitted when the United Nations Security Council acts under this Chapter 7, Article 39 under Chapter 7 of the United Nations Charter provides the Security Council shall determine the existence of any threat to the peace, breach of the peace, or act of the aggression, and shall make recommendation or decide what measures shall be taken in accordance with the Article 41, Article 42 to maintain or restore international peace and security. The significance of Article 39 is that it provides the United Security Council with the power to determine the existence of any threat to the peace, breach of the peace, or act of aggression. In response to a threat to the peace or any act of aggression, the United Security Council may authorize the use of force, either through United Peacekeeping Mission or by coalition of the forces of states in order to restore international peace and security. After this significance, when Article 5, paragraph 1 gave the definition of the crime of the aggression, which subject to the defined by the member states. But the significant event happened in the 2010 Kampala Review Conference, which is very significant regarding the crime of aggression. The discussion continued on the issue of the crime of aggression. The negotiations were done by the Perpetually Commission for the ICC 99, 2002, and the Special Working Group on the Crime of Aggression 2003 to 2009. In 2009, SWGCA found a consensus agreement on the definition of the crime of the aggression. The Secretary General in 2010, Rome Statute State Parties President Evan Shendier in Kampala. The 2010 Kampala Review Conference used the definition and could thus focus on other outstanding issues, including the condition for the exercise of the jurisdiction. The state party therefore adopted Resolution 6 by consensus. The resolution amended the Rome Statute to include, among others, the new Article 8 bis. You will find I'm giving you extra tip or extra knowledge regarding the reading of the article sections. When the article bis mentioned, it means that is a new article. When the article mentioned, like in this screen, you are seeing 8 bis, 15 bis, and 15 ter. 15 ter means old definition, existing, but 8 bis means that there's an amendment has been provided. The resolution amended Rome Statute includes, among the others, the new Article 8 bis containing a definition of the crime of aggression, and new Article 15 bis and 15 ter containing provision on the condition for the exercise of the jurisdiction. It was also included in the statute that the assembly of the state parties will have to take a further one-time decision to activate the court jurisdiction no earlier than 2017. Very much important trigger mechanism. What are the trigger mechanism for the crime of the aggression? This is very much important, students. Act of aggression include invasion, military occupation, and annexation by the use of force, bombardment, military blockade of ports. The Rome Statute is a treaty that established international criminal code, and Article 8 bis paragraph 2, the Rome Statute defines the act of aggression to mean the use of force by a state against the sovereignty, territorial integrity, or political independence of another state, or in a manner inconsistent with the Charter of the United Nations General Assembly resolution. The trigger mechanism include: number one, state party refers to the prosecution; number two, refers to the prosecution by the United Nations Security Council under the Chapter 7 of the United Nations Chapter; number three, the prosecutor own initiation of the investigation and prosecution. The Security Council and Article 8 the Security Council must act before the ICC can prosecute an alleged crime of the aggression against the individual. So it is a condition imposed by uh, this Article 8 bis. Means before investigation or prosecution is started by the ICC, so Security Council must act on it. The argument is that under Article 39 of the United Nations Charter, the Security Council has exclusive competence to determine an act of state of the aggression, and the court cannot proceed with a case without the determination by the Security Council. Article 39 of the United Charter gives clearly authority for the Security Council to decide on aggression. Once a determination has been made, the ICC prosecution could investigate any individual who might be responsible in a criminal context. The Article 5, paragraph 2 of the United Nations Charter does not require a prior determination by the Security Council. The argument is that Security Council has primary but not exclusive authority to determine an act of the aggression. The absence of a prior Security Council determination would not preclude the court from the proceeding with a case. Article 39 United Nations Charter provides the Security Council shall determine the existence and threat to the peace, breach of the peace or act of the aggression, and shall make recommendation or decide what measures shall be taken in accordance with the Article 41, 42 to maintain or restore the international peace and security. Thereafter, the United Nations General Assembly. The United Nations General Assembly has 6 situations declared certain acts of aggression. For example, China against Korea in 1951, the occupation of Namibia by the South Africa in 1963, and Israel against Iran, Lebanon, and the Palestinian people. Resolution of the United Nations are not binding but are considered highly persuasive. And ICJ's role, International Court of Justice, would be determined whether or not a state has committed an act of aggression, both in the form of judgment and in the form of advisory opinion, as in Nicaragua case and the Democratic Republic of Congo case, which I have already shared with you, students. You can look into those cases in order to, because these cases are the real time scenario based cases. In these cases, how law apply, you can learn. It could play a role by providing an advisory opinion of the request of the General Assembly or the Security Council. The ICJ would reach a preliminary decision on the state aggression following determination by the Security Council that a threat or breach of the peace has occurred. A state party can refer a situation to the prosecutor, or a prosecutor can initiate investigation properio moto, by one's own motion or one's own initiative, if the crimes within the jurisdiction of the court appear to have been committed by the national of the state party or a territory of the state party, who is bound by the Article 15 bis of the amendments to the Rome Statute. The ICC granted jurisdiction over crime of aggression cases. However, this jurisdiction can only be exercised after the 1 year from the time of a minimum of the 30 states ratified the amendment. For example, if the amendment are ratified by less than 30 states, notwithstanding the period Maybe after 10 years or even 2 years, the consenting states would not be bound as the 30 state ratified threshold would not be met. For example, if 30 states have ratified the amendments, the court jurisdiction will only take effect after 1 year has elapsed from the day of ratification. From the wording of the Article 15, paragraph 4 bis, we understand that the only countries bound by these amendments are the consenting members to the Rome Statute. This is the line with the public international laws teaching on the sovereignty of the states and supremacy of their consent, bound by a given treaty pursuant to Article 12, paragraph 1 of the Rome Statute. When a country ratifies the Rome Statute, it subsequently accepts the court jurisdiction over the crime of aggression. And further, when a state commits the crime of aggression, they will be bound by the amendments to the Rome Statute unless show that they objected to amendments. A rejection of the court jurisdiction followed by the lodging claim to the register will be termed as the prima facie evidence of the rejection of the court jurisdiction. So students, these are the significance we have discussed with the I initially give introduction regarding the crime of aggression. Thereafter, some historical development and historical facts in order to understand how crime of aggression evolved and how it is difficult to discuss because the use of force on another country and how it will decide which country is aggressor and which country acted is defend their territory, their cultural morale, and their people from the rampage and from the aggression of the another state. So there are a lot of discussion, there are a lot of conferences, and there are a lot of committees, and there are a lot of recommendation and suggestions has been placed, but the mostly the big powers they are against the crime of aggression. Those veto countries like America, China, Russia, France, and UK. Initially, they have not consulted on the crime of the aggression, but later on in 2010, the landmark event happened. And this crime has been included in the jurisdiction of the ICC in the Article 8, but with the condition that as per the Article 39 of the United Nations, before start prosecution by the ICC, a General Assembly will act, and ICC has to wait for any recommendation or any remarks or any discussion given by the Security Council, General Assembly of the Security Council. So that was the students' concluding remarks on our detailed lecture, which I have delivered to you in order to understand the crime of aggression and give you a lot of reference of the lot of articles and the laws in order to understand the crime of the aggression. I hope this part of lecture make you understand the initial background of the crime of aggression. So here I'm going to end this session. After the short break, I will continue the second session of the same today's lecture, that is for the element of the crime of the aggression. Thank you.